Very good afternoon, good evening to all of you, and then happy month of August to all of you. So, those of you who were with us the last meeting, we commenced discussing illegality and public policy, and we noted that despite the fact that all the elements of contract might be present, and more so they may be any vitiating factor as such as mistake, misrepresentation, duress, or undue influence. Nevertheless, the contract which has been made by the parties may be unenforceable for the simple reason that it is illegal or contrary to public policy. And this illegality or being contrary to public policy might have been at the very inception of the contract when the contract was being made, or at the performance stage of the contract. And we look at examples of contracts which are considered as being public policy and illegal, and for that matter, unenforceable. Contract to oust the jurisdiction of the court, contract considered prejudicial to the interests of the states, contract which promotes immorality and all that, or contract to interfere with administration of justice, or contract which seeks to promote corruption use in public life. All those things we saw contracts which are illegal and so on. Then we also came to look at the consequences of illegality, or when we say that the contract is contrary to public policy, what happens? We noted that if money have been paid or property has been transferred under such a contract, its recoverability will depend very much upon a number of factors. For example, we noted that where there has been a change of mind, a change of heart, what we call the locus penitentiae, before the implementation of the illegal contract or the contract contrary to public policy, then where there has not been performance, substantial performance of the obligation and all that, the fact that there has been locus penitentiae, there has been that change of mind and heart, would be a very mitigating factor, which will let the court say that the other party who had changed his mind before the others implemented the legal or control or contract contrary to public policy will be allowed to recover monies that he or she might have parted under it. So we saw that. And then again, we also saw how the parties who said not to be equally guilty, where they are not in pari delicto. That is to say, if the person seeking the assistance of the court to recover the monies paid under the illegal contract be demonstrated to be somewhat innocent compared to the other party. So we say that he is not in pari delicto. Then on basis of that, the court could allow him to recover whatever money that he might have transferred. And it was within that context that we mentioned to you the evolving development in the law, following recommendation of the UK Law Reform Commission on how to treat illegality and contract the public policy, and especially so how Justice Dr. Dateba, in the Supreme Court decision of the City and Country West Limited against Accra Metropolitan Assembly, sought to introduce what we call the structured approach towards the resolution of the consequences of illegality, or how to recover money under contract, which is contrary to public policy, and where he said that we don't have to use just the common law approach that assume that if you cannot establish the parties are not in pari delicto and all that, then it's like automatically cannot recover. But he was talking about the structured discretionary approach, meaning that you need to have regard to all the circumstances of the very particular case before you make a clear determination as whether the party who is seeking to recover the money under the illegal contract be assisted or not. As you remember, under the City and Waste Limited against EMA, we notice how the company was actually innocent in the sense that it is not part of the AMA, and not being part of the AMA, it does not know the internal arrangement for making contract. Later on, when you do company law, there's something we call the rule in the Techman case and all that. So the Supreme Court of saying, yes, they've done the work. If you don't let them get a payment, there's going to be some kind of unjust enrichment and all that. So that is that the bar was saying, quite apart from the structured discretionary approach, you could also rely on the restitution claim to justify the allowing the City and Country Waste Limited to recover payment for the work that it has done for Accra Metropolitan Assembly. And we also move on to discuss, we started discussion of a contract in restraint of trade. And we said that contract in restraint of trade may lead to a situation where in an employment contract, there is...
everybody's writing the name. Let me write some.
Yeah, so where in a employment contract, there may be a clause saying that should the employee stop working for the employer, he is not going to work with the rivals in a certain duration and all that. Then we also saw the same thing applies to sale of goods, no, sorry, sale of a business. Where you sell your business, you want the seller to make some undertaking and restraint, saying that he or she will not set up like a similar business within a certain geographical radius and within a certain, you know that. And we also saw that there could also be contractual arrangement in which one supplier may insist that a particular business entity should take all his or her or all her supplies from that particular supplier. How do you call it? The Solus or the dealership agreement, as it were. And we noted at the outset that all these types of arrangements in which there is the incorporation of one restraint clause or another are fundamentally detrimental to very good public policy operation. The right of every person to earn a living by engaging in a legitimate business. And the public policy would like everybody not to impede his ability to use his labor or his like his intellectual resource or whatever, be able to earn a living. So where you enter into some of these restrictions, are actually undermining that. And for that reason, we noted that the law sets a very high bar, which must be met before a restraint clause will be considered. So we were looking at the number of examples of that. So we look at example of restraint clause in relation to contract of employment, and we stated the test, like, in other words, the criteria which must be satisfied before the court could say that a contract, sorry, a restraint in the contract of employment is a legitimate one and is enforceable. And that test, the twofold test, is first of all that the restraint clause must seek to protect some legitimate interests of the employer, such as the clientele, confidential information, trade secrets, or trade connection. If that is what is seeking to protect, then the law says that that is legitimate, because without those things, the business of the employer will definitely collapse. So it is legitimate for the employer to extract an undertaking from an employee that he's signing that should he stop working with him, he is not going to undermine these matters to steal the trade secrets or expose it, or the database on customers or clientele and all that. That is fine. Then the second test is that the restraint clause must be reasonable in the circumstances, and the reasonableness of it will depend upon, like, the scope, in terms of the duration, in terms of maybe even like something like the geography, like the location in which you are trying to prohibit the person from working, or so on and so forth. So we noted all this as some of the court will take into account. And then we discussed the case of and Sons against Saget, and I think we're about looking at the case of Littlewood's organization against Harris. And in Littlewood's organization limited against Harris, we noted that the defendant, Paul Harris, was employed as a director by the plaintiff, Littlewoods, land company which competed with Great Investor Source Limited for the major share of the mail order business in the UK. So, clause in the defendant's contract of employment provided that should there be termination of contract of employment, now the employee was not at any time within 12 months, following the termination of the contract, enter into contract of employment with the Great Investor Source Limited, or any of its subsidiary companies, or be involved in the trading or business of Great Investor Source Limited or its subsidiaries. So the employee, that is a defendant in this case, eventually resigned from his job with Littlewoods. Those who have been to the UK know that the Littlewoods is like the over there, informing them that he had accepted an offer of employment from Goose Limited. That is a Great Investor Source Limited. Now, Littlewood certainly became aware that the former employee is doing the very thing that he had contracted not to do, not to work with this direct rival of Littlewood. So accordingly, Littlewood brought an application for an injunction to restrain the employee from breaching his contractual obligation. And when the matter eventually traveled to the court, the English Court of Appeal, it held that that is a Littlewood were entitled to protection of a reasonable covenant restraining Harris, that is a defendant, from going to work for a rival company in the mail order business within a limited period of leaving their employment. Now, our good friend Lord Denning made an interesting dictum which we quote. It seems to me that this really was a case where Littlewood had a great deal of confidential information, which Paul Harris had acquired in the course of his service with them, and which they were entitled to protect by a reasonable covenant against his going away in taking it to their rivals in trade. So you notice that when we are talking about the tests which the law sets in the necessary test to pass before a restraint clause in a contract of employment will be considered valid and for that matter enforceable, was that it must protect the proprietary interests of the employer, which is considered legitimate. An example of that is protection of what they call like the trade secrets, what you call the confidential information. And here, Denning was of the view that having regard to circumstances of the employee, he had certainly certain confidential information which he didn't have to use to the detriment of his former employer. So let's keep that in mind. Let me switch on condition. But we need to draw a very important distinction between protecting trade secrets or confidential information, which is protectable interests, and preventing an employee from making use of knowledge and skills which he has acquired in the course of his employment, which is not protectable. So there are two things. The knowledge an employee has acquired in the course of his employment is not protectable because it's part of the development of the person, of the employee. Every rational employee, you go and do any work, if and only if you are serious, you will definitely leave that work having acquired certain knowledge, certain competencies, which you did not have before going to do that employment. Now, that type of knowledge or those type of skills are not protectable, and you cannot make a valid contract in restraint trade concerning that. But where you come across trade secrets or confidential information which are protected in that particular business or that particular employer's work, and it's not something that you giving access to, but for the fact that the employer trusts that you are a lawyer and all that, and then that is why you are giving. Now, that type of information is protectable, and it can be a subject matter of a valid restraint in the contract of employment. So on that, it is quite instructive for us to look at the case of Herbert Morris Limited against Sazabel, where there was a 7-year restraint on the employee, and the House of Laws held it to be void, as being simply an attempt to prevent the employee making use of the technical skills and knowledge which he acquired with his employer if he took up employment with a rival company. And the acquired skills and knowledge were not owned by the employer. So let's get the difference. So it protects, as I said, confidential information or secrets, but not acquired technical skill and knowledge. because those things are not owned by the employer. The employer does not have what they call any proprietary interest in that. Those of you who do intellectual property law, later on, you will come across some of these discussions again. So if you look at the Herbert Morris against the Sazabel, the plaintiff employed the defendant as, pay attention to the facts so that you appreciate why the court said that the particular restraint will not be considered as the typical or the valid restraint in the contract of employment because of what is sought to protect. So let's look at the facts. So the plaintiff company employed the defendant as a draftsman and then as an engineer on a 2-year contract. The terms of this contract contain a covenant by the defendant that he will not, during a period of 7 years, from ceasing to be employed by the company, either in the United Kingdom or Ireland, carry on either as principal, agent, servant, or otherwise, alone or jointly, or in connection with any other person, firm or company, or be concerned or assist directly or indirectly, whether for reward or otherwise, in the sale or manufacture of pulley blocks, hand overhead runways, electric overhead runways, or hand traveling cranes. Now, besides the protection of the trade secrets or confidential information, the employer is also considered entitled to protect his customers' connection by preventing the employees from soliciting or enticing his customers away from him. Just imagine your employees left your work. He or she has a database of your clients or your customers. The next day, he starts calling them and directing them to a new place where he's working. And you'll be sitting in your office or in your company, and none of your old customers or clients is coming. And you later get to know that is your employee, your ex-employee, who has diverted all of them to the new place where he or she is working. And that is why this protection is important. But the position of the law is that a restraint of this kind will only be valid of the nature of the, depending upon the nature of the employment. That is one. And for that matter, where the employee, by the nature of his duties, has personal contact with the customers, some influence over them, then it will be legitimate to have such a restraint clause in that employment contract. But if the employee concerned is such that he doesn't have direct contact with customers, or even if he did, it is not such that it has any influence over them. That is another thing. Of course, if you go to, let's say, the banks, right? You go to the so-called relationship officers, relationship managers. And they, for example, have direct personal contact with the customers and they have influence over them. So if the relationship manager, for example, leaves one bank, he or she can divert the interest and attention of certain high-value customers to move money from there to wherever he's going. Now, in the case of Fletch against the West, a lifelong restraints on solicitors managing clerk was held by the House of Lords to be valid and enforceable. Because don't forget, we are talking about where the particular person had contact with the customer, influence over them. Just like your clerk you're working with in chambers, he has access to all your clients, their contacts, and all that. So if he decides to, for example, stop working with your firm, you could effectively divert all or most of the clients away, except where you get the clients who will be able to defy such a. So that was a similar situation which we encountered in the case of the Fletch against the West. And the managing clerk in that case, while working in the time of as a managing clerk, agreed with his employer that he would not practice within 7 months of time off town hall after leaving his employment. And the court did not hesitate to enforce such covenant, despite the fact that there was no restriction on the duration. Because we noted in the beginning that as to whether a restraint clause will be valid or not, among other things, will depend upon the reasonableness of it. And the reasonableness of it will also depend upon the duration of it. Now, in this particular case, there was no duration, so to speak, but the court said that having regard to the circumstances, it was reasonable for the manager to be so restrained, as it were. As I said, that having regard to the position that the manager, he would definitely have had a significant influence over the clientele. And for that matter, there was no point in placing a time restriction on that. There are so many examples that we can cite to illustrate that. Just answering the cases and then you move on. So, for example, look at the case of Lucas T and company against Michelle. There too, we had a salesman, the defendant therein, contracted he should not for 1 year after the termination of his employment solicit orders within his trading area from present customers and those whom his employer supplied during the previous 12 months, and to deal in the same or similar goods that he sold. Later, when an action was brought against him for breach of contract for doing the things that he has agreed not to do, the court held that the first clause, not to solicit orders, was valid and enforceable, but the second clause, if you look at the second clause of dealing, was unreasonable and void, having regard to the nature of it. So that is how these matters work out. But you may want to, again, contrast that to the case of SW against man. There, an agreement by a manager of a book makers not to engage in a similar business with his employer within a 12-mile radius on the termination of his employment was held to be invalid, as the manager had little or no influence over the firm's clientele, and in fact, communicated with them mainly by telephone. So here, just reinforcing the point that if the employee does not have significant influence over the clientele, then there's no point in restraining him in that respect. And so that is a point we should note. And that was why the court took the view that the employer had no valid interest to protect. The primary aim of the clause was simply to prevent competition, declared void. We know the law on fair competition. Contract and restraint of trade and employment and all that, in one way or the other, seeks to undermine competition. And if you are just trying to emasculate yourself from competition and acquire some kind of a monopoly, right? Get some kind of a monopoly, then that one, the law will not protect you. That is not the point. So that is not the point. So let's keep that in mind. Yeah, so we've talked extensively about this second factor in determining validity of the restraint clause, which is that it must be reasonable in the circumstances of the whole contract case. And for that matter, the position of the law is that an employer is not generally entitled to restrain an employee from carrying on a business which is different from that in which he was employed. Yeah, so if, for example, someone had been employed, is working for you, doing particular type of job, and you make him or her to make an undertaking that should he stop working with you, he's not supposed to do a certain type of job. If that job you are training him or her from doing is not related meaningfully to the particular job that he was doing in that employment, then you have not satisfied the test of reasonableness. So that is the point we are making. So you cannot restrain an employee from carrying on a business which is different from that in which he was employed. So let's suppose that someone is working for you in the clerical department, and you say that should you stop working with me, you are not going to work with any rival company in the area of its engineering. I mean, that's unreasonable because what this employee was doing for you not anything related to engineering. So if you want to restrain him, you have to restrain him in respect of the very thing that he was doing in your establishment. So that is the point. And related to that is also the scope of the restraint. The restraint must not be too excessive or wide in area of coverage than is necessary to protect the employer's interests. So the coverage, the scope in terms of geography, in terms of the intent and all that, should not be wider than really necessary to give protection to the employer. So that is, and that was why Mason against Provident Clothing and Supply Company Limited. Provident Clothing Limited employed Mason as a local in its Arlington branch in London. So his job, as a canvasser, that is like you are recruiting, his job was to obtain members and collect their installments. He had no duties outside his assigned districts. Now, Mason covenanted not to assign, he covenanted not to enter into similar employment within 5 miles of London for a period of 3 years. Now, before I move on, some of you will be wondering, so wasn't it the employee who actually signed on that restraint? So why shouldn't he be held to it? You see, when it comes to employer-employee relations, you notice that the employer definitely has a stronger economic muscle. And every employee, you are hungry, you need work to do. And when you are being recruited, you don't have the luxury of time, the luxury of opportunity to actually be asking unnecessary questions or be challenging things. You just want to be given the job. So all these things we are talking about, they will not actually dawn on you until in future you stop working for that particular employer, and then you want to move on, and then your former employer decides to hold you to the contract that you signed. And that is why we have this thing. So it's quite normal. So in the Mason's case, as we noted, Mason covenanted not to enter into similar employment within 5 miles of London for a period of 3 years. Now, the House of Lords held that the clause covered an area which was much greater or wider than reasonably required for the protection of his former employers. And as such, it was void and non-enforceable. Provident clothing were entitled to protect themselves against the danger of a former employee canvassing or collecting for a rival firm in the district which had been employed. But the restraint which the company was trying to enforce was too wide. You are just in the, if you look at the district that here, those who know the geography of London, there's the Islington area. So if you are just in the Islington area, why will you try to get the protection for the entire London, both Greater London and all that? I mean, that is a way to assess. That was why the court considered it unreasonable in the circumstances, and for that matter, void. Yeah, so similar point was noted in Commercial Plastics Limited against Vincent. There, the plaintiff company, Commercial Plastics, were manufacturers of tin, PVC, calendared plastic sheeting, a rapidly developing section of the plastic sheeting. So they had 5 principal UK competitors with whom they shared most of the markets. But plaintiff's preeminence was in the field of manufacturing tin, PVC, calendar sheeting for adhesive tape. And the plaintiff company employed the defendant, Vincent, a plastic technologist, to coordinate research and development in the production of PVC. It was a condition of the defendant's employment that do not seek employment with any of the CP's rival in the industry for 1 year after leaving the plaintiff's employment. So the defendant was sued, and then the plaintiff sought an injunction. But the action failed because the clause was held to be too wide than necessary, because the clause was wide, worldwide, like the whole world. But the plaintiff did not require protection outside the UK. So where protection within UK would just have been enough, why would you like to get the protection which extends to the whole world? And that is quite unreasonable. Yeah, the other point to note is that the reasonableness of the restraints also can be looked at in terms of time. So the restraint must also be reasonable in terms of time, not just geographical scope. So that where the restraint is excessive as regards the time of operation, it will be unenforceable. If you prescribe excessive time than really necessary to protect, that will be considered unreasonable. And for that matter, it will be unenforceable. That was why in the case of Fellows and Sons against Fisher, a conveyancing clerk employed by a law firm in Walthamstow agreed that for 5 years after the termination of employment, he would not be employed or concerned in the legal profession anywhere within the postal district of Walthamstow and Chingford, or solicit any person who had been a client of the firm when he had worked there. Eventually, when there was an issue in the matter, the court was the view that the 5-year restraint was too long and as such was void and non-enforceable. So the takeaway is that the duration of the restraint, for it to be reasonable, should not be excessive. But of course, if you contrast Fellows and Sons against Fisher, with the case of a Fitch and the West, which we have already seen. You notice that in Fitch and the West, the restraint was a lifetime, and it was a lifetime restraint, and he was not supposed to work for another solicitor within a radius of what, 7 months of a time of time. But same was considered valid by the court. Why? Because in that case, he had direct contact with all the clients, and he had great influence over them. So the court thought that if he was not restrained in that regard, he could just divert all the clients to another place and will collapse the business of his former employee. Okay, so that is enough for contract, of restraint in relation to employment. You want to now talk about restraint in the sale of a business. Contract in restraint with respect to sale of business. That is where you have a business and you sell it to another person. The person buying may want certain assurances that you're not going to make a fool of him or her. So let's suppose that let's take, okay, because we are, let's say something that we can relate to. What is some of the famous business? Well, let's suppose that you bought, let's say, Poku trading, right? Poku trading, of course, now with the emergence of these modern supermarkets and then mini supermarkets, it's somewhat, but for quite some time, it has significant goodwill in terms of customers and all that. So let's suppose that you were buying that. You want to get assurance from the owner of that business that he will not make nonsense of the purchase that you are doing by just acquiring a site 1 meter or 10 meters or 20 meters away from you and build another shop, even if it's not going to use the name Poku Trading, and then just be doing like the same thing that you are doing and all that. And by the time this new buyer is aware, all the people who used to go to the old Poku Trading to buy things will be there because they will know that you are that new place. So that is the kind of thing we are talking about. But and for that matter, where you have a contract for sale of business, as I have indicated, it is quite normal for it to have a clause by which the seller of the business agrees or undertakes not to set up a competing or similar business. The courts have no difficulty in upholding this type of clause on the basis that it protects the ultimate interest of the buyer of the business. And here, unlike the employer-employee relationship, as I told you, employer-employee relationship, the employer has a higher bargaining capacity or strength than the employee. But when it comes to the sale and purchase of business, the two entities are dealing at arm's length. They are negotiating on equal footing. Because if you have a business and if I have the money to come and buy it, it means that I am not somebody that you can just walk over. I also have a similar economic strength as you, the vendor. And for that matter, when we are negotiating and all that, nobody is going to play the other. And that is why the courts are more happy to uphold validity of restraint on the sale of a business. Nevertheless, it is pertinent that for a restraint in respect of the sale of business to be held valid, two requirements must be satisfied. Two requirements must be satisfied. So we would like to look at these requirements. So first and foremost, there must be a genuine sale of the goodwill of the business. There must be a genuine sale of the goodwill of the business. And a very good case will illustrate that is the Vancouver Malt and Sick Brewing Limited against Vancouver Brewers Company Limited. In that case, a company that was licensed to brew beer, but which did not in fact did not brew any beer, agreed to sell a business and to refrain from manufacturing beer for 15 years. Since the company was not actually brewing the beer, the purchaser could only have paid for the tangible assets, that is, goodwill, and the purchaser had not therefore bought the promise not to brew beer, and so he could not enforce it. And that is why the point is that there must be a genuine sale of the goodwill of the business. So in this particular case, yes, you are actually set up to brew beer, but you have not been brewing the beer. And for that matter, in terms of maybe customers knowing that or beer is brewed here and all that, that will be unsustainable because you are not doing the brewing, in fact. And that was why the court said that since there was no actual brewing, the purchaser could only have paid for the tangible assets. Now, the second requirement for the validity of the restraint business is that the restraint must not be too wide in this scope. Just like what we discussed in the case of restraint in the employment contract. And for that matter, the restraint will not be valid if it purports to give protection on the purchaser that goes beyond the actual business sold to the buyer, to the seller. Yeah, so you have to let it be just enough. It shouldn't be too wide. If it is too wide, it will not be treated valid. For that matter, if we look at British Reinforced Concrete Engineering Company Limited, again the Sheffield, the company manufactured and sold BRC road enforcement. I mean, just the adoption of their own names, British Reinforced Concrete. BRC road enforcement throughout the United Kingdom. The defendant had a smaller, more local business selling road enforcement, but he was not involved in manufacturing these products. The plaintiff company bought the defendant business, and the defendant covenanted that he will not enter into competition with them, either in business or in the employment of a rival, in the manufacture or sale of road enforcement. Now, later, the defendant was employed by a road enforcement company and subsequently sued by the plaintiff company for breach of his agreement with them. And the matter came before the court. The court came to the conclusion that had the clause be confined to sales, it would have been valid, but to include the manufacture of reinforcement made the restraint wider than was necessary and therefore void. Because in the court's view, the plaintiffs were entitled to the protection of their proprietary interests in the defendant business, which they had just got, but they were not entitled to protection in respect of their wider business interests. The defendant business was concerned with the sale, not the manufacture of a particular type of road enforcement. So it was not reasonable to restrict the defendant's future activity in such an extensive way. So therefore, where you are selling the business, and the buyer would like to get certain protection. It will relate to what the business which he is buying was doing. If there's a particular new thing which is yet to be done, and it's not the case that it was already being done, then you cannot let the vendor of the business make any undertaking in that respect. And were you to do that, the restraint will be considered too wide and, for that matter, unreasonable. Okay, let's say a few words about the Solus Agreement before we go. Just a second. Sorry, just a mess up here. Here. Yeah, my screen is frozen. Just a second. Yes. Okay, so we're just about starting the last aspect of the discussion of contract and restraint of trade. That is the Solus Agreement. The Solus Agreement. And Solus Agreement is a name given to a contract by which a trader will restrict his orders to one supplier. So usually what will happen is that a supplier will actually extract undertaking from the particular trader or business entity that all his or her needs will be ordered from that and only that particular supplier. And that is why we call it the Solus Agreement. And certainly, you notice that such an agreement undermines competition. And for that reason, it needs to also pass the reasonableness test. before it will be upheld as valid by the courts. And the reasonableness of the Solus Agreement is determined in terms of duration of the restraint, and if the restraint is not contrary to public policy. A very good case is the case of the Esso Petroleum against Harper's Garage. The parties entered into agreements relating to supply of Esso Petrol to 2 garages belonging to Harper. By these agreements, Harper agreed to purchase petrol only from Esso, and in return, they obtained a small discount on the price. For the first garage, the tie was to last for 4 years and 5 months. But for the second garage, a loan of £7,000 was made, and the tie was to last for 21 years, while the mortgage repayments were made on this loan. Now, later on, an injunction was sought to prevent Harper from buying petrol from another supplier. And the courts held that the exclusive dealing agreements, that is the Solus Agreement, that's another way of saying Solus Agreement, exclusive dealing agreements, were within the restraint of trade doctrine because Harper had given up a right to sell other products. Though the restraint, which operated for 4.5 years, were not longer than was necessary to afford adequate protection to Esso's legitimate interest in maintaining a good system of distribution. The other tie, that is a tie of 21 years, was held to have gone beyond a reasonable period. And for that matter, that particular restraint agreement was void. A similar point was made in the case of Petrofina Limited against Martin. The defendant broke the agreement by selling other mix of petrol, and the plaintiff sought to enforce it by means of an injunction, preventing the defendant from doing so. And the court held that the restraint involved was not valid because 8 years of 12 years, or its duration of 12 years was unreasonable, having regard to the protection that he wanted. Now, all that these cases tell us is that the law is trying to negotiate, right, a very fine balance between people's freedom to enter into all manner of trading arrangements and all that, which is fine, and at the same time to guard against fair competition, because where you don't guard against people's attempt to undermine fair competition, you end up encouraging monopoly, and that is inimical to good of the economy and society. We can contrast the 2 cases that we have seen, Esso Petroleum on one hand, and then the Petrofina Limited on the other hand, with the case of the well-known cases of the Alec Lob Garages Limited against Total Oil JV Limited, where the Court of Appeal upheld a 21-year restraint tie. 21 restraint was tied to a loan agreement as reasonable in the circumstances because the loan was part of a rescue package which greatly benefited the garage. And for that matter, the court was of the view that there were opportunities for the garage to break the arrangement after 7 and also 14 years. And for that matter, it was generally fair, having regard to the circumstances. Then we also have the price fixing agreements, agreement to limit supply or output. But all these things are actually against free competition, as it were. And for that matter, the law frowns upon it. But the other point to note is that it is also possible to have restraints protecting other interests. Protecting other interests which do not fall within any of the categories that we'll be discussing. That is, we've so far discussed the three types of categories. Restraint in employment contract, restraint in the business, and then the restraint in the exclusive dealing agreement or Solus agreement. But quite apart from that, there could be some other restraints, and especially if you go into the realm of intellectual property, learn more about this. So in case you were interested in knowing more, we could look at the case of Schroeder Music Publishing Company Limited against Macaulay. Tom Macaulay was a young and unknown songwriter. He entered into an agreement with the defendant Music Publishing Company, whereby the defendants engaged in exclusive services. Under this agreement, Macaulay gave the company the copyright of all his compositions for the next 5 years, with a further 5-year option. In return, was to receive royalty payment. The company could end the contract by giving Macaulay 1 month written notice, but there was no corresponding provision to allow Macaulay to do the same. If you remember, when we were learning, I think the topic, capacity to contract, we came across a similar case, the case of Di Francisco and Barnum. I don't know if anybody remembers that, Di Francisco and Barnum, very similar circumstances to Schroeder Music against. So the company was not even under any obligation to publish any of Macaulay's songs, though this agreement was not a contract of employment as such. Macaulay sought a declaration that it was contrary to public policy, as being unreasonable restraint of trade and void. And the company argued the doctrine of restraint of trade was inapplicable to its standard form contract. Eventually, the matter got to the House of Laws, and the House of Laws held that the restrictions in the agreement between Macaulay and Schroeder Music Publish Company Limited were not fair and reasonable, in that they combine a lack of obligation on the company's part with a total commitment on the part of Macaulay. So if the company, for instance, chose not to publish his work, he will be unable to earn as a songwriter. Therefore, the contract was unreasonable restraint of trade, and Macaulay was entitled to declaration. And then what I am interested in at this stage is to just take any questions you have, and then we move on to start the discussion of the discharge of contracts. Yeah, so if there is any question, look at it, and then let me, so that we start another.